Thank you and welcome to the Cose WebEd webinar. Today's topic is building your HR policies and employee handbook and will be presented by Liz Crosby. Before I get started, I would like to take a moment to go over a few housekeeping items. My name is Adina and I will be the webinar organizer for today. We want to make sure today's presentation is extremely valuable for you, so we ask that you submit all questions by clicking on the question button in the control panel and typing your question. Your questions are only visible to me. I will collect all submitted questions and we will do a Q&A with Liz at the end of her presentation. Now for the main event. I would like to introduce Liz Crosby. Liz Crosby is a partner at Buckley King and has over 27 years of experience in the areas of employment law and workers' compensation. She is an OSBA board certified specialist in both areas. She represents employers in all areas of labor and employment law, including employment counseling, preparation of handbook compliance with all federal and state employment laws. She has been named an Ohio Super Lawyer yearly since 2010. In 2016, Ohio Super Lawyers named her one of the top 50 women attorneys in Ohio and top 25 women attorneys in Cleveland. Without further ado, I would like to hand it over to Liz Crosby.
Welcome, everybody. I'm glad to have you join me today to talk about creating a better workplace, and by that we mean through policies and procedures. So it's a great day for a webinar since it's not a great day outside, and to that end, let's get started. A lot of people ask me, where do I start with my handbook? What do I need to have in it, and what am I allowed to have in it? And the answer to that is pretty simple. Almost everything that you would want to put into a handbook in terms of your rules and policies that you want to have handled is legal if it supports a legitimate business purpose, or sometimes referred to as a bona fide occupational qualification. A legitimate business purpose relates primarily to things that support the organization, that support its mission. Now, I don't know many organizations that have gone to the trouble of, especially for small businesses, identifying their mission, vision, and values. This is an essential starting point in constructing your handbook. Why? Because if we go back to this slide, almost everything is legal if it supports a legitimate business purpose. Your policies are going to be there to support that legitimate business purpose, or in this case, the mission. What is the mission? The mission is the reason the organization exists. It describes what makes the organization special or different. Let's take a look at a mission statement that I thought was good. This is for Advanced Auto Parts, as you can see. It is the mission of Advanced Auto Parts to provide personal vehicle owners and enthusiasts with the vehicle related to products and knowledge that fulfill their wants and needs at the right price. So what we have here is the essential components of what makes Advanced Auto Parts Advanced Auto Parts. It is vehicle-related products for both owners and enthusiasts that fulfills their wants and needs at the right price. They take a step further. What sets them apart? They have friendly, knowledgeable, and professional staff that not only educate and problem solve, but also help inspire their customers. I found that a great mission statement. So when thinking about how we're going to draft a handbook, we're going to look and see who we are and what is important in our policies to maintain that presence. The next thing we have to look at is vision. The vision is where the organization is heading. Things that consist of the vision is what are our specific goals, where do we want to be in 5 years, what is the direction of the organization. Here's a great vision statement by DuPont: creating sustainable essentials to a better, safer, and healthier life for people. So they are looking forward to sustainable in safety and health. And that could also be part of their core values, which we'll get to in a minute. But that's their vision. That's where they want to be. That's what they want to be known for. The final thing, you probably already guessed it, is core values. The core values are those things which your organization will not compromise in performing its mission and reaching its vision. So things like honesty, integrity, timeliness, those are considered core values. Here's another example. I really like Zappos core values. And if any of you have ever shopped at Zappos and used their phone-in feature, you can really feel it come through in talking with their representatives. They have 10, and their number one is probably a sign of the times. It's to deliver that wow experience through service. I won't go through each and every one of them. I also like number 3, create fun and a little weirdness. But these are their values. Do more with less. Be passionate and determined, and be humble. So why is it important to discuss the mission, vision, and values and have an identification in your organization of what those are for you? We've already said that it equals business purpose or bona fide occupational qualification, but it does a little bit more. It tells your employees who you are, where you're going, and what's important. If employees aren't part of that organizational concept, if they aren't part of this trilogy, they're really a step up above the machine. They're there to punch a press or sell a candy bar or some other kind of meaningless task. But if they understand that they are part of an organization that has direction, that knows who it is, and has values, it's much easier for them to buy into it. More importantly, and from a legal perspective, it's much easier to support the integrity of your policies and procedures if they're tied to this. So let's take a look at what prevents these elements from just floating away like balloons on a windy day. What keeps the mission, vision, and values supported in your organization? Well, it's twofold. It's the job description and it's the handbook. Now, I'm not going to spend a lot of time talking about job descriptions, but they are essential, and so I do want to digress for just a minute on this important aspect of your HR policies. When we look at the life cycle of an employee, starting up in the upper left-hand corner with recruiting, when you recruit for a job, you are telling a vast audience out there a need that you have. So when you think about creating a job ad, it should fully describe the needs that you're trying to meet. So let's take our punch press individual who is going to work this machine every day. What are the essential characteristics that you want the public to know in order to recruit the right individual? Do they have to be timely? So, for example, if you've got a crew and you need that individual as part of a crew that, they might be on a line or something, their daily attendance is going to be essential. It's going to be a very important part of their job. And so we're going to include that in a job description. Do they need to know how to operate a certain type of machine? Maybe it's a CNC machinist that has to be trained and skilled in that. You're going to want to put that in the ad. Moving out of the punch press industry to, say, a doctor, well, they're going to need to be licensed in Ohio and have passed all their medical boards. So that's a qualification that would need to be in the ad. When we think about the physical or educational requirements, that's the easy part. Now let's think and go back to our mission, vision, and values. And what about our mission, vision, and values is important in recruiting? If we are promoting timely response to customer needs, again, we go back to attendance being an essential qualification. If we're going to be friendly, like Zappos, then something that might go into our job description is enjoy working with people, have a, I don't know that I'd go so far as to say a sunny outlook on life, but something along those lines. And with the vision, one of the things that we found through various studies is that the current millennial generation, or the gig generation, which is another word for them, likes to know that they are part of the future, that they can play a part in reaching those goals. So it may be important, if that's the age group you're recruiting from, or recent college grads that you're recruiting from, to make sure to include some aspect of your organization's vision in the job description, or I'm sorry, in the job description, but in your recruiting ad. So let's move on then in the lifeline of the employee to the application process. One of the things you may have heard is under the ADA that you have to ask employees if they're able to perform the essential functions of the job with or without an accommodation. That question should actually be on every job application. If the applicant does not have the job application in front of them, the job description in front of them at the time they're applying for the job, they can't possibly answer that question. So I think it's really important to have a written job description that goes along with the application. Now, if I was in front of you right now, I'm sure there would be a lot of hands up saying, but our jobs change all the time. And maybe that's a bullet point that goes into your job description, is that these duties may change from time to time, but the core responsibilities will remain the same. You're going to come in and operate the CNC machine, that sort of thing. So you want to have at least something very relevant to what's both physically and educationally required, as well as experientially required, for that applicant to be able to say whether or not they can perform the essential functions of that job. The same is true when you go into the interview and post-offer testing environment. During the interview, you want to stay focused on what the organization's needs are. You can ask questions that would relate to the mission, vision, and values. So, for example, if you've got an applicant in front of you that's had, 4 jobs a year for the last 5 years, you might ask them if they are looking for a short-term situation. If they like that kind of variety, you can spin it as very positive for them. Or if they're looking to be part of the growth of an organization. If you do post-offer testing, such as physical exams, psychological testing, drug testing, of course you don't have to wait to make an offer to do drug testing, but if you do any of those, any post-offer testing should relate to one of those essential job qualifications contained in the job description. So leaving the job description sort of kinda, we now move into orientation. You've hired the individual. You want them to be familiar with their responsibilities, the needs for which you've hired them, and you also want them to be familiar with the mission, vision, and values of the organization, as well as its policies and procedures which support that mission, vision, and values. That is where the handbook comes in. I recommend that during the orientation process, which a lot of organizations now refer to as onboarding, a great deal of time is spent in going through the handbook and educating the individuals not only about the policies that exist, but tying them into the mission, vision, and values. In other words, the why the policies exist. After we've gone through orientation and the individual's been employed for a while, we rely both on the job description and the handbook in conducting performance management. And at that time when separation occurs, we will also rely on both the job description and handbook in certainly for cause terminations, but also to some extent in separating for voluntary resignations. So there's your lifeline. There's the essential components of your employee life cycle. And now let's get into a discussion on the handbook. At this point, Adina, I'm happy to take any questions regarding the background of supporting the handbook, if there are any.
All right, I have one question from the audience. It says, I work at a staffing agency. Do I have to have the ADA and job description for the applicants when they don't know what they are applying for?
Oh, that's a great question, because you're right. They're going to be placed where your customers need the assistance, whatever openings you have. So in that particular incident, what I would do is wait to placement. At the time that you have the job available, you know what it is. At that point, it would be helpful to hand it to them and say, here's the placement opportunity. Can you perform this job with or without accommodation? Now, I'm going to go ahead and guess that the person that asked that question is going to say, what if my customer doesn't give me a job description? At that point, I would probably indicate, what you know about the customer, what type of operations it is, your understanding that it's a standing job or a sitting job, your understanding that they want someone with experience, and this person had written on their application that they had the experience. So you work with what you can. If your customer will give you a job description, bonus points for that. That's very helpful. But I also think you want to take that opportunity to go through what the staffing agency mission, vision, and values is. Your mission is not only to provide employment on maybe a temp to perm basis or on a temporary basis for individuals, but also to fulfill needs of industry in a temp to perm type situation. And so what's going to be important in that environment is that you show up, because if the individual doesn't show up after you've placed them, it doesn't look good for the temp agency. You know, they may go to somebody else at that point. And that if those opportunities are a temp to perm type situation, you express to them what a great opportunity this can be, because it can lead to permanent employment. It's a great organization, and so forth and so on. Are there any other questions before I move forward?
That's it. That's the only question I have at this time.
Excuse me. I should have said at the beginning that I have weather-related allergies or something going on, so I apologize if I cough. And that was one of those moments. So let's talk about the handbook. I don't know how many of you already have a handbook. If you don't have one, this is an outstanding time to create one. And I know it might seem like a daunting experience, and I'm not going to gloss over that. It's a lot of work, no doubt about it, especially if it's an effective handbook. If you just want a handbook to put on the shelf and say, we've got one, and if we get an EEOC charge of discrimination, I can submit this as part of the investigation, pull one off the internet. But if you want it to be a living and working document on which you can rely, then pay attention, because that's what we're going to cover going forward. So the handbook, aside from supporting the mission, vision, and values, also acknowledges state and federal workplace laws, which presumably means that you are complying with them. Now, most federal laws apply to employers who have anywhere from 15 to 50 employees. If you've got less than 15 employees, then federal laws are probably not going to apply. However, Ohio has companion laws, meaning they're similar laws, and they apply to employers with 4 employees. And so for that reason, anything we really talk about in terms of the law is probably applicable. Where it isn't going to be applicable in Ohio, I will point that out. Okay, so what do we need to have in a handbook? Well, an EEOC or an EEO statement, equal opportunity statement, is probably the single most important thing to have. But your needs are going to be individual to your organization, as we've discussed, because they're going to support the MVV. So let's just start from the beginning. I like a welcome page. I think it's a great opportunity to share with your employees your mission, vision, and values, the purpose of the handbook, maybe the history of the company. If that is part of your value system or your vision, then it's really important to include it. And maybe for a letter from the president, welcoming the new employee. None of these are needed. It all depends on what flavor your organization is and what message you want to send to your employees. When we talk about the purpose of the handbook, Adina, I don't know, can you see when I do this with my cursor? Yep. Okay,
yeah,
great.
I could totally see it.
Thanks. I forgot to ask you that. So when we talk about the purpose of the handbook, it's usually twofold. If you're going to include a purpose, it's to make your employees aware of the policies and procedures which are necessary to the effective running of the organization, and to answer employee questions they might have on a day-to-day basis, as well as identify the various benefits associated with working for the company. So here's basically, this is how I like to divide up my handbook. I like to have the welcome page first, and then after the welcome page, I usually put our table of contents. And if any of you would like a table of contents to kind of use as your prototype, please let Adina know, and I will make that available. Once you get through the table of contents, the first topic area I like to cover is general workplace policies. And we're going to go through each and every one of these. The general workplace policies are primarily your compliance with state and federal regulations. Then we go into specific workplace policies and procedures, things that are significant for your organization. Then the one that employees always go to first, the time away from work, insurance and benefits, and then the termination page. So let's get started on general workplace policies. Here are your state and federal compliance policies. The first, and as I said, probably the only real necessary policy that you're going to need to have is the EEO policy. And that says something along the lines of, our organization does not discriminate in any aspect of the employee life cycle, including recruiting, hiring, discipline, promotion, termination, or any other aspect of the job on the basis of. So I'll run through those very quickly for you. Those include race, color, religion, creed, age, sex, I'm going to come back to sex in a minute, physical abilities, genetic information, and while this isn't included in the EEO policy, I included in my policies membership in an armed services organization. So I said I would come back to sex. This is probably, you've heard, a relatively hot topic right now because the federal discrimination laws are expanding the definition of sex. So sex includes sexual identification, meaning gender identification, transgendered individuals. Many states and federal Federal Court of Appeals have expanded it to include homosexuality and lifestyle choices. So sex is one of those hotbeds. I have clients that like to refer to it as gender orientation, sexual orientation, all sorts of inclusions in that sex, and they spell them out in their handbooks. That's perfectly permissible. You want to conclude your EEO statement with the following phrase, or any other characteristic protected by state and federal law. The next policy, which you do not have to have, but I recommend it, again, it supports, it tells the federal agencies that you have complied with state and federal laws, but it also lets your employees know why you do certain things that you do, and that's the eligibility to work, also known as the I-9. Why do we have an I-9? That's what you put in your eligibility to work policy, basically that the federal government requires individuals to present 2 forms of identification upon hire. If you've got an individual who doesn't produce that and they aren't hired, clearly you've got a basis for termination. They were never hired, but they may apply for unemployment, who knows, and there you've got your policy. Workplace accommodations. This is going to relate to both religion and disability. And the policy will state something along the lines that individuals with disabilities who need an accommodation should ask either their supervisor or the Human Resources Department for assistance. Now, you don't necessarily have to put in anything about religion, but if an individual has a religious need, and this is a bona fide religion, not, I worship dogs that, track across the moon. It has to be, a mainstream religion, and it has to be a bona fide necessity practice of that religion. So, for example, Saturday is our Sabbath. I can't work Saturdays. They are required to ask you. You're required to accommodate if you can. Remember, accommodations have to be reasonable. If it's not reasonable for the employer to accommodate the specific need, then we don't do it. The smaller you are, the harder it's going to be to accommodate. One of my favorite examples is my dry cleaning client hired a woman. She shows up for the first day of work. She's got a dog with her. The dog apparently senses when she's going to have a diabetic moment. There's no medical support for it. There's no licensing of the dog or certification that the dog is qualified for that sort of thing. We tell her she can't have the dog. On top of it, it's a dry cleaner. I can't think of anything much worse than bringing a dog into the dry cleaner with the clean clothes. And so we were successful on that. That did go to the EEOC, and the EEOC did support us on that. So, the accommodations can be anything from dogs to, hours worked and that type of thing. But the importance of that policy is to advise your employees that if they need the accommodations, they have to ask for it. You do not have a crystal ball, despite what most of them think. They have to ask, and at that point, you will get into what's known as an interactive process with them to determine if that's something reasonable the organization can do. Moving on from that, discrimination and harassment. Now, harassment is it's bullying based on a protected class status. We've already identified in our EEO policy what those class protections are. Harassment means that you're bullying them based on that. The fact that someone's just mean and nasty makes them an equal opportunity harasser. It doesn't make them a violator of state and federal law. So if they're just mean and they're mean to everybody, that's not a violation. But if it's based on a person's sex, on a person's sexual orientation, or gender identification, if it's based on their religion, their color, it's illegal. Discrimination, likewise, can take two different forms. It can be direct discrimination. I'm sorry, we do not allow women to work in that department. No reason why, they just don't do it. That's direct discrimination. We don't see that very often. People usually don't say that anymore. They're a little more educated today. But what they will do is have qualifications for jobs or criteria that have what is known as an adverse impact on a protected class. So I'm going to give you a really great example of this when you talk about recruiting. If you're only recruiting new hires from your all-white workforce, you're having an adverse impact on other protected status employees. On the other hand, if you're advertising your job openings on Monster.com, the classified ads, anything that's got a large reach, you are not going to be having an adverse impact, presuming, of course, that the advertisement doesn't in and of itself restrict that. With both of those, in addition to having, we don't do these sorts of things, and anybody who feels that they're a victim of it can report it, you want to have a reporting procedure, and you want to follow it. Acts of discrimination or suspected acts of discrimination and harassment should be reported to A, a supervisor, B, human resources, and if that's not satisfactory, the president. The reporting procedure should also indicate that you will conduct an investigation, and that to the extent that you can keep it confidential, you will, but when there are allegations made, not everything can be confidential. I want to say one more thing about harassment. When we talk about sexual harassment, it isn't necessarily a supervisor and the young woman that is being harassed. Oftentimes it can be a coworker who is witnessing inappropriate sexual conduct in the workplace. So, maybe the secretary that's sitting outside of the boss's door, and clearly there's something going on with a subordinate in the office. That secretary can feel very harassed, even though she's not a party to it per se. Excuse me. So moving on now to whistleblowing. This is more of a discretionary policy. I like to put it in particularly if the employer does things with the federal government. Whistleblowing is that act where an employee will report what they believe to be illegal activity to, say, OSHA or the Federal Trade Commission or some other governmental entity. OSHA is usually the big one. So I like to put a policy in that, we are very, and of course this will go to your mission, vision, and values, we are very, what's the word I want? our reputation and our actions are very important, and if anybody witnesses activity which they believe is inconsistent with federal, state law, or our mission and vision and values, it should be reported to your supervisor, HR, or the president. This does two things. The crackpot that decides to call OSHA over, a guarding issue could have gone to a supervisor to report it instead of going to OSHA. And so, to some extent, it creates a credibility issue for that person who's decided to go outside of the organization to report a perceived problem. So that's one of the reasons I like to put that in there. One of the arguments against it, of course, is that everybody thinks they're Sherlock Holmes and you don't necessarily want to plant seeds. And if you're not in a compliance type industry, it may not be as important. We have two more to go over here. Retaliation. Basically, the retaliation policy says that anyone who is exercising their state and federal rights will not be retaliated against for raising concerns over those rights. Pretty simple. And then at-will employment. So every single handbook has to have the at-will policy, just like the EEO policy. And the employment at will policy states as follows. All employees, let me back up, it's a little different than that. You have been hired by our organization on an at-will basis. This means that either you or the organization can terminate the employment relationship at any time and for any reason. That's the sum and substance of it. No one that I know of, and I wish I could see a show of hands out there, but no one that I know of fires somebody for no reason. There's always a reason. And what happens when we don't have a reason, when we fire somebody because they're an at-will employee, and we don't say, well, it was an attendance issue or it was some other issue, we go back up to here to the EEO, and they may enjoy a presumption of discrimination if they're in a protected class because we don't have a reason. Now, I'm not telling you not to have an at-will policy. You should have an at-will policy. But both for the reasons I just stated, as well as a fairness issue, and employees believe that cause is fair, I don't recommend that you plaster it everywhere. Excuse me for 1 minute. Okay, I avoided a cough. Okay, so let's move on to the next section. Before I do that, are there any questions?
Yes, actually. One of the questions is, should you have them ask for accommodations in writing?
Well, you don't have to. So, for example, if they don't ask for it in writing, but they've asked, and they go and you don't do anything about it, and they go to the EEOC, they don't have to have done it in writing. However, what has to be in writing, if it's for a medical condition, there has to be a note from the doctor describing an overall, an immune disorder, or, they don't have to say, they're at end-stage renal failure, although typically you're going to know that, but they have to give the doctor has to give some kind of description of the disability so that, first of all, we know that it's a disability under the ADA, and also what the accommodation is. This person can't go near chemicals. This person has to sit 8 hours a day, that type of thing. What happens once we get that is then we try to work within the parameters set by the doctor. And we go back to the doctor and we say, how does this job description look for your patient? And the doctor says, everything's good except. And we go back and forth. That's what's called the interactive process. And we look to see if it's reasonable for us to do that, if we can get the job done by doing that. But you do not have two things under the ADA. One, you do not have to recreate the job. And two, you don't have to bump somebody else to accommodate that individual. Either you can make accommodations to the job that they applied for or not. Okay? Any more?
Yes, one more question. Our employees view their handbook online during onboarding. They sign off on it during the process and they have the ability to download the manual for their files. Is this sufficient?
You know, more and more companies are doing that, and yes, it is sufficient. As long as you can attest that that person has access to it and that they had a thorough review of it during their onboarding. There will be certain policies that you may want to post throughout. You know, you can't dock an individual's pay because they forgot to punch in. However, you can discipline them if they're a frequent violator of the time clock policy. So that might be something where you would post a sign, don't forget to clock in, your points depend on it, something like that if you've got a point system or something like that. Okay to move on?
Yes.
Okay. So in workplace policies and procedures, if you've got an introductory or probationary period, spell it out, but be detailed on why it exists. There's an argument that a probationary period, once it's ended, makes the employee permanent. That's not true, and you want to make sure that they understand that at the end of a probationary, orientation, or introductory period, they're still an at-will employee. I generally like to see a section on the workday. What are our hours? If those are going to vary from employee to employee, you know, or job to job, and say your supervisor will provide you with your work schedule. Generally, the office is open from, oh, I'm so sorry. Do you have a dress code? Is that important to your mission, vision, and values? Going back to my dry cleaner, it is incredibly important that their front counter people show up well-groomed with all the buttons on their clothes. They are selling a groomed appearance. That may be the same situation. And before anybody, stop typing if you are, piercings and tattoos are not protected classes. If it's important for you, if your clientele or vendor or customer base is older and you know, not buying into the tattoo and piercing scene, you don't have to allow that to happen unless there's a religious reason for it, and then we go into that weighing. Okay, so now if you need to type, go ahead. Tracking time, we talked about breaks and lunch. A couple things I want you to be aware of there. There is no requirement that a person get a break. That is a fiction, and that is something that arose out of the union movement. That's negotiated benefit for labor members of the labor organizations. Same for lunch unless you're in a particular industry which requires it, such as transportation or something. I generally like to put in when the pay periods are, what to do if there's something wrong with a paycheck, who do you report it to, and overtime. Really quickly on overtime, it should say that you may be asked to work overtime and you are expected to do so. We will give you as much notice as we can. If you can't work the overtime or you refuse to work the overtime, discipline may be administered. The other thing is, you should also put in there that employees are not permitted to work overtime without authorization, because you don't want somebody handing in a time card at the end of the pay period that's got, you know, 160 hours on it. Personal performance, compensation, and advancement. That's a section where do we do reviews? When do we do them? What do we look at? Compensation. Please, please, please do not tell your employees they aren't allowed to discuss their compensation. They are. It is a violation of the National Labor Relations Act to prohibit employees from talking about the terms and conditions of their employment. Advancement. If you like to advance from within, put it in your handbook. Let people know. General workplace conduct. This is basically your litany of thou shalt nots. You know, the following conduct is prohibited: sleeping on the job, stealing, removing safety apparatus. Generally, that is a list without an end. Do not assume that everybody knows that they shouldn't do that, because the very person that violates the, oh my God, can you believe it, rule is the one who's going to file for unemployment and actually get a claim. In fact, one of my favorite stories is a guy stole tires from a tire manufacturer out of the back. He was on camera, caught him dead to rights, and unemployment gave him his benefits. So if anybody's on this line from OBES, maybe you can help with that. Data security, privacy, and confidentiality. Now, this is your electronic data. You know, what are you going to do with cell phones? Is there privacy associated with laptops? Can they use cell phones in the shop? All that sort of thing. Two things that I want you to include that are really important. Number one, employees should not presume that they have a right of privacy. They do not. You are there to protect the workplace, so everything is subject to searching. And then confidentiality. Employees are exposed on a daily basis to the employer's confidential information. That must be protected at all times, including when they leave. Confidential information includes such things as our vendor list, our customer list, our processes, our procedures, the way we do things, the ingredients, if you're manufacturing a product, that sort of thing. And that's going to be unique to every organization. What is confidential information? And then safety, really important. A person who violates a safety policy or removes safety apparatus is subject to discipline up to and including termination. If they hurt themselves or others, you have the claim. Your only recourse is to terminate the individual who violated those policies. Okay, so I think that's it. So there are, let me go back just real quick. There are other things you can include in the workplace policies and procedures. Reporting injuries can go in there, maybe under safety. Maybe it goes under the workday. Phoning in. What's the requirement to phone in when you're sick? Those are pretty essential because, you know, a lot of our policies, we develop them based on claims we get, unemployment claims or workers' comp claims or discrimination claims. If you've terminated somebody because they're always tardy, but you don't have a tardiness policy or how to report off, it's going to be harder to win your unemployment claim. I can't tell you how many workers' comp claims I've won because there was a policy in place that was violated. Now, that doesn't necessarily go for safety issues, but it might go for a number of other ones. Policies become very important in those situations. All right, let's talk about time away from work. This is, again, whatever you do, it's fine. You have no requirement to give any paid time off unless you're, you know, you've got a union and then you bargain for that sort of thing. But if you give paid time off, identify what it is. So, for example, with holidays, a lot of employers do not pay the holiday. They won't pay for a paid holiday if the person takes the day before or the day after off. They have to work the day before or the day after. Paid time off may be just that. A lot of employers have moved away from vacation time and sick time to some certain you use it for whatever you need. Do they use it or lose it? What happens at the end of the year? Are they able to bank a certain amount? All of that sort of thing should be spelled out in your policy. What do you do about bereavement leave and who does it apply to? Does, you know, my Aunt Ethel twice removed from my, you know, former stepfather's first marriage count? You know, usually it's close family, but then again, you know, some people have relationships that go beyond that. So you decide. Workers' comp, usually your policy is going to state injuries must be reported immediately. What are you going to do about jury duty? Do they get paid for jury duty? Very briefly, I want to talk about unpaid leave. If you have more than 50 employees in a 75-mile radius of each other, you are required to comply with the Family Medical Leave Act. If you are not currently complying and you meet that standard, please contact an attorney. You must have family medical leave available to those employees. If you are not required to comply with family medical leave, you may have an unpaid leave policy. Spell it out. This is a hotbed for discrimination if you don't have a relatively solid policy. It should say something along the lines that unpaid leave is discretionary based on business needs at the time the leave is requested. You can have up to 2 weeks. If you need more, you can apply for more, but no event have more than, you know, whatever works for your organization. And then military leave. Military leave is required of any employer with 1 employee. What this means is that you will protect an individual in the military who is called up for active duty. And we could spend a whole hour on military leave, but to some extent you protect their job for up to 5 years depending on the circumstances. It is not paid and you do not have to continue their health benefits. However, you do have to protect their job so that when they come back from their deployment, they have a job to come back to. Okay, any questions before I move on to the next section?
Yes, we actually have quite a few questions I want to get through.
Okay.
So can you forbid certain hairstyles or hair colors?
If there's a legitimate business reason for it, absolutely. If it's for religious reasons, then you have to work through that. But if it's not for religious reasons, sure. You got to be careful that it's not a pretext for some other discriminatory action on your part. But for the most part, yeah.
Okay. And then another question. On FMLA, can you include employees outside the 75-mile radius?
You can, but you are not required to.
Okay. And then one last question. Where can I get samples of actual handbooks for both company and staffing agency? Fairly new companies, so want to see how others have theirs set up.
Well, you can ask, if you're the staffing agency, you can ask your clients to see their handbooks. I would start there. And as I said, I'm happy to give my table of contents to anyone. Excuse me. Giving somebody a handbook, they're pretty valuable. We don't just give them away. And that's something you want to sit down with your attorney and kind of go through and make sure that the policies are related to a bona fide job qualification or legitimate business purpose. Is that it?
Yes, and actually someone gave a suggestion on that topic, so ERC is a good source for the handbook and policies in case anyone is interested. So I just wanted to put that out there.
Excellent. Okay. Insurance and benefits, this is really quick. If you've got them, usually I just say the company currently has an offering of whatever they are. These things change so much that typically you're just going to refer the individuals to the Human Resources Department for plan documentation and current offerings. The only difference in this insurance and benefits is some employers offer their employees discounts. maybe you're a retail organization and you let your employees purchase at 10% above cost or something like that, this would be the section to put that in. If there are limitations on it, for example, they can't have a store balance in excess of $100. They won't be permitted to purchase if it goes over that, something like that. You're going to want to put that in there. And then termination. I like to have a separate section on termination. Termination is a fact of life in the employee life cycle. Is it voluntary? And what qualifies as voluntary? Do you want them to give notice? If you want them to give notice, please pay attention. If they give you 2 weeks and you show them the door, they may be eligible for unemployment, particularly if their new job falls through. If you make them work through the 2 weeks, then they aren't going to be eligible. More importantly, you don't have to make them work, but you do have to pay them. So, and I wouldn't put that in your policy, but what I would say is that, we request a 2-week notice. And then if you don't want that person to stay on, just say, we're going to pay you for the 2 weeks. Good luck and adios. What's the no-show, no-call policy? If they miss 2 days or 3 days without calling in, is that a voluntary quit? What happens for cause? How do they get their last paycheck? What's the benefits policy? Return of company property. Do they have your stuff? They've got to return it. Earned but unused paid time off. What about insurance continuation? And usually, if you've got less than 20 employees, it's going to depend on whether or not they're eligible for unemployment benefits. If you've got more than 20 employees, then they're going to be eligible under COBRA. And then what happens with their final paycheck? Do you mail that? And does that final paycheck go out on the normal pay date? These are some things that we keep in the termination section. This last section, and I don't have a lot of time, I have very little time, but you can have a section on dispute resolution. If you want to try to stay out of the courts, you can have a binding arbitration and mediation policy. This is a two-edged sword. If you go into binding mediation and arbitration, then you don't really have an opportunity to say, hey, we were right, and throw this case out. However, it is cheaper in some instances to go this route. If you decide to do this, I would talk with your legal counsel about the risks and benefits of dispute resolution as a way of avoiding the courts. And that will have to be a separate agreement with each employee. And then at the back of the handbook, you're going to have your forms and acknowledgments, your receipt of the handbook. Do you have a separate form for drug testing? Do you have a separate form for payroll deductions? So, for example, if you pay for your employees' uniforms and they don't return them, and you're allowed to, deduct that from their final paycheck, you better have a payroll deduction authorization in order to do that. Do you let them use your equipment, either for personal use or outside of the business area? If so, let's have an agreement on that. And then with respect to the dispute resolution, you'll need an arbitration agreement. So that's your handbook. I'm happy to stay on the phone as long as you need me to talk about any other questions you might have.
Okay, so I have a few questions, actually quite a few questions that came in. So someone needed clarification on the payment. So if someone gives you a 2 weeks and you decide to have them leave early, you still have to pay them, is a question. So I think they needed further clarification on what you discussed earlier.
So you don't have to, but if you don't pay them, if you let them go, if they say, okay, this is my 2 week notice, I'm going to quit working for you on June 15th, and you say, goodbye, we don't need you, you've basically terminated them at that point, because they're going to work till June 15th, and they've told you, I'm ready, willing, and able, and you let them go. So unemployment will give them benefits. However, if you say, we appreciate your service, here's your 2 weeks pay, unemployment will not give them benefits. That's the only reason I raised that issue. If you aren't worried about unemployment, then don't worry about paying them.
Okay. And everybody, I'm getting quite a few questions about the PowerPoints. They are available if you look at the handout section of your webinar. I did put the PowerPoint accessible in that field. I'll also email it to you after this call because Liz, a lot of people are asking for the table of contents. So if you could send that over to me, that would be great.
Absolutely, and I should have done that to begin with because I almost always offer that up. And again, it pretty much has everything in it, maybe, and certainly more than I've covered today. We had not a lot of time to go over a lot of really important things, and hopefully I've just wet their whistle a little bit.
Perfect. So we have a couple questions. Are we allowed to require employees to pay for damage they have done to either our equipment or property or to our customers' equipment or property?
Well, here's the short answer. Probably not. And it's a short answer because you can't do anything to your employees' pay that takes them below minimum wage. So let's say they're making $10 an hour and they've worked the 40 weeks, it's a $400 check, and they've got $150 in damages that you're going to take out of their check. That's a problem. You can take it out of their check for, over a 52-week period if they stay with you. Excuse me. But at no time can they go below that minimum wage requirement. In addition, they're going to have to have signed a payroll deduction agreement that I understand that I am responsible for this equipment. If I cause the damage to it, I will be responsible for the co-payment or the deductible or whatever. So you can have that agreement, but even that agreement will not trump keeping that person at minimum wage.
Okay. And a few people have been asking for the audio for this webinar. I had some trouble with the recording, so I'm hoping I could salvage it. So if you're looking for the webinar, along with all the other webinars that Cose hosts, we'll make that available on the cozy.org /events page. If you look on the left-hand side, there's a section for webinars. So I'm hoping I could salvage the recording from this session. So stay tuned, and it should be available in a couple weeks on that section. So I have a couple questions that came in. How do you address the hairstyle issue without being discriminatory? Is this a setup for a lawsuit if it's not specifically spelled out in the handbook?
Well, in your dress code, you can be relatively vague and say that we expect individuals to report to work well-groomed in traditional office wear, something like that. Well, orange hair is not traditional unless they're a redhead. Blue hair isn't traditional in any case. And so, what you don't want to do is fire them. What you want to say is, look, this is inappropriate in our workforce because we're a very conservative industry, and even if you're not, because, it doesn't send the image that we want to present. We'd like you to go home and change your hair color. If you can't change it, put a wig on. If you can't put a wig on, then come back when you're able to. Those sort of things. If the person can't articulate a religious basis or some other medical basis for it, then you don't have a problem. If they do, then we have to go into the accommodation issue. If it's the same for religion. Now, if you have permitted individuals not in a protected class to have blue hair, but someone's in a protected class and you have prohibited of them, yeah, you are walking right into a buzzsaw lawsuit. But, as long as it's applied across the spectrum of employees, then you're okay.
Perfect. Another question is, are employees view their handbook online? Oh, I'm sorry. We already asked that one. The question below it, sorry. Oh, sorry.
That's okay.
I think okay. If they leave on the cusp of 90 days and you have to sign them onto your benefits for the 90th day, you decide to let them go early to avoid that, but still pay them for the entire 2 weeks, does that make them eligible for the benefits?
That depends on your plan documents. Probably not, but you should talk to the insurance broker about that, or the agency that wrote the insurance plan.
Okay. Well, that concludes the webinar. I have no other questions from the audience. What I could do is, everyone that's on the call, I will send you Liz's contact information. So if you have any questions beyond this webinar, I'll provide you her contact information along with the PowerPoint and the table of contents that she so graciously wanted to share with everybody. So I'll provide that after this call. Thank you for your time, Liz. We really appreciate you taking time out of your day, and hope you feel better. Goodbye, everybody.
Bye-bye.
Bye-bye.